Hello class, we are going to start chapter 33 in this video. We're going to be adding to our knowledge of agency law, moving from formation of an agency to the liability that results from such a relationship. And then we'll finish up with a few points on the termination of an agency relationship. Liability is based on the type of authority an agent has. So in this part one of the videos that I make for you, we're going to just be looking at the 5 different types of authority. I want to show you something in your textbook right now. This is a concept summary that the authors of your book have compiled, and this can be handy when you're studying. All right, so we will talk, and I'll have a, and you've read in your textbook, but to have a summary where it's all in one place, short information, small amount of information, that's helpful to you. You've studied law long enough to know that there's a lot of detail. And sometimes, though, you don't need all that detail as you are reviewing. All right, so I'm just kind of scrolling through quickly this concept summary so you can see it, but it is in the first section of chapter 33, all right, following the section on authority by ratification. All right, switching back. Right to the PowerPoint. Let me put the slide back into slide view for you. Oops. There we go. And we'll start looking at the 5 types of authority. All right, the first type of authority is express authority. This means that the terms that the principal and the agent are operating under are clear, they're definite, they have been stated between the two of them, or they are in writing, probably preferably in writing. A good example of express authority would be found in a document, the power of attorney. All right, so this is a pretty common document in business. In case, though, you've not seen one of these, let me switch out again to your textbook. Hope I can do this quickly. But there's an example, the front end of the chapter. I hope I did not skip it, but here it is. All right. They give you a fairly complete document here. You may or may not be able to see it all at one time, but you can certainly magnify it and get a better look at the language of this power of attorney. Now, a power of attorney is a common document in the business world. All right, I'm fairly sure you can find it on the internet. You used to be able to go to an office supply store and you can buy, several copies because they are very commonly used. All right. You can read through this one in your book and you can see how it clearly spells out the authority that the principal is giving to the agent. Right. So example of express authority. I'll head back now to my PowerPoint. Second type of authority would be implied authority. This means that the authority is not specified, has not really been stated, but it can be inferred. The authority can be inferred from the principal-agent relationship. And it can be based on the powers that are reasonably necessary to complete the work that has been authorized. The third type of authority is apparent authority. And I put the word estoppel up there because when I start to describe apparent authority to you, it will sound like an agency by estoppel. So there is a relationship between the two terms there. Apparent authority and agency by estoppel are very similar. All right. So what is apparent authority? Apparent authority is authority that an agent has based on what the principal has said to a third party, or based on how a principal has acted or conducted him or herself. All right. So the third party who has witnessed this conduct or has heard what the principal has said now relies on what was said or what was done and changes his or her position. And if that happens, the principal is not going to be able to deny that the agent had authority to act. Right? This is illustrated in the case from your textbook, which is Lundberg versus Church Farm Inc. All right, this is case 33.1 in your text. Let me give you some facts for this. Actually, I think I can switch out to it as well, just so you have it on the screen while I'm talking. Oh. Go back to your textbook. Let me go out here. All right, here's the actual case. I'm sorry, I'll just try to leave that up there on the screen for you. All right, and so in this case, the plaintiff, he contracted with Church Farm Inc. That is managed by a Mr. Herb Bagley, and the subject of the contract was to breed mares with a horse owned by Church Farm. That horse is named Imperial Guard. All right, we're talking thoroughbred horses. All right. So the contract was clearly signed by the manager, Herb Bagley, as follows. This is what it said. Gilbert C. Church by H. Bagley, and that contract guaranteed to the plaintiff in this case, all right, that they would be able to have or raise 6 live foals. Right. After some time and 4 attempts at breeding, however, only 1 foal was born. And then Imperial Guard, the horse, was moved from Illinois down to Oklahoma. So the plaintiffs sued. They didn't feel like they had gotten what they were entitled to under the contract. All right. What was the defense? Church Farm said that Herb Bagley was not authorized to sign, to make a commitment as he had. All right. Now, this is what, though, was shown at trial, that in various ads, Church Farm had listed Bagley as their manager. They had directed inquiries to be made to him, that he would respond to them. In addition, Bagley lived on the farm, and he handled the operations for Church Farm. He was the person who answered questions, and he met with visitors who came to the farm. So by all appearances, Herb Bagley was the manager who had authority, and the plaintiff's reliance on what he said to them in their negotiations and the commitment he made in the contract, okay, that was all justified. Right? So the court affirmed the finding, the judgment for the plaintiffs in this case. All right, so we again are just looking at, do we have apparent authority? Did the principal put the agent in a position so that, and then did the principal indicate to third parties that this agent was acting with authority? Yes, in this case. So we have apparent authority, and we could have an agency by estoppel. All right. Going on, our fourth, oops, was that the fourth already? Oh, no, I skipped one. Sorry, class. Our fourth authority is emergency authority. And this is this occurs when we have an unforeseen occurrence that demands some action. So if you recall in the previous chapter, I talked about how you could have an agency form on an emergency basis by operation of law. Remember, I gave you the example of the bus driver who might have an accident on the road with a full bus load of passengers. Well, in that emergency situation, the bus driver would have authority to act on behalf of the bus company to try to assure that the passengers are taken care of. That would be emergency authority. That's an example of emergency authority there. And we'll move into the last, the fifth type of authority, which is ratification, authority by ratification. All right, you're familiar with this term. We have seen it now a couple times this semester. You know it from Business 12A, right? Ratification means that something did not exist to start with, but after the fact, after someone has acted, if someone accepts that performance, someone affirms the previously unauthorized action or the conduct of the agent, we're going to have agency by ratification. All right. Now, there are some required elements, and they're listed here on the screen for you. So what are those 4 required elements? The agent must have acted on behalf of the principal. The principal must know at the time of ratification all the material facts of the situation. The principal must affirm the agent's actions in entirety. And the principal must affirm before any third party has a chance to withdraw from the transaction. And that's an important point. It will be relevant when we take a look at a couple, or at least one particular problem at the back of the chapter. All right. So just keep in mind, it's always after the fact. The principal had no agency perhaps to start with, but affirms whatever the agent has done. All right. And one good example of this would be if benefits are being received through something a so-called agent has done, and the principal continues to receive these benefits without any protest or any inquiry or any refusal of them. That's pretty clear. That's going to be authority by ratification. All right. So this is the end of part 1. In the video that I make for part 2, we'll start looking at the liability that an agent and a principal may have.